Good afternoon, everybody. My name is Oliver Westmoreland. I am an OSC registered level 3 immigration advisor, and I am senior immigration lawyer at GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is British Naturalisation Application and criminal convictions. I'm going to tell you very briefly what a British Naturalisation Application is. It's where an adult who is not British applies to become a British citizen. If the application is successful, they have successfully naturalised as a British citizen. I will tell you very broadly and briefly and basically requirements for naturalisation. There are residence requirements that you've lived in the UK for long enough and not been outside the UK for too long during a relevant qualifying period. Immigration status requirements, you must hold the correct immigration leave. English language, life in the UK test requirements. Good character requirement, which is important for this particular topic. Good character, it's a very broad thing. It covers very prominently criminality, covers other things, can even cover, as you might have discovered from some other of our videos, CCJ's county court judgment. It's a very broad thing. It can cover anything that the Home Office thinks it should cover. The rules are intentionally vague and imprecise. Criminality is, of course, a major topic when we're thinking about good character. What is criminality, I hear you ask? Well, let me go through this. This is a topic that's averagely complicated. If you have been imprisoned, you have a criminal offence on your record, fairly obviously, I suppose. If you've been fined by a court, you have a criminal record. It doesn't matter how much the fine was or whether or not you've paid it. If you've been fined, you have a criminal record. If you have a disqualification from driving, you have a criminal record. If you have an absolute discharge or a conditional discharge, you have a criminal record. If you have a caution, now this surprises or shocks some people, if you have a caution on your record, you have a criminal conviction. Caution is where the police say you did something bad, illegal, do you admit it? And you say, yes, I'm sorry. They say, well, we're not going to prosecute you this time, but be careful in future, and you're issued with a caution. This counts as a criminal conviction in Home Office terms because if you've been issued with a caution, it means that you have admitted the offence. So there's a sort of logic behind it. Talking about other things that are less than criminal offences, we mentioned CCJs, FPNs, fixed penalty notices. If you get given a fixed penalty notice, this does not qualify as a criminal conviction, but any of those things in that short list I gave you, as far as the Home Office is concerned, these are all criminal convictions. Mm-hmm. Do you have any questions by any chance, Mr. Shah? You look as though you have.
I do. If someone is applying for naturalisation, is it compulsory to declare their cautions or convictions?
Yes.
Okay. And could you tell us briefly, please, what is the difference between caution and conviction?
Caution is where you admit the offence, but you are not prosecuted. Now, it's not up to you whether you get prosecuted or not. It's up to the prosecuting authorities of the police. But you have admitted the offence, but you do not get prosecuted.
Okay. And let's say someone has a caution or a conviction. Can they still succeed with their naturalisation application?
That is a very good question, and it needs a very precise and detailed answer. Home Office have changed things over the last year or two. Let me tell you in some detail how it works. Home Office say that a person will normally, maybe not always, but normally be refused if they have received a custodial sentence, that means in prison, of at least 12 months in the UK or overseas, or consecutive sentences which add up to at least 12 months, or they are a persistent offender who shows a particular disregard for the law, or have committed an offence which is called serious harm, or have committed a sexual offence and their details are recorded on the police register of sex offenders. Now, that's a discretionary, will normally be refused. So probably you'll be refused, just maybe not. On the other hand, the mandatory counterpart person must be refused if they have a custodial sentence of less than 12 months or a non-custodial sentence, like a fine, for example, and this is how the caseworkers, how their thinking is directed. Caseworker is not satisfied on the balance of probabilities that they are of good character. This is an overarching assessment. So the first part is custodial sentence less than 12 months or non-custodial sentence. That must exist. Second part of the decision making, Home Office thinks, is this really a bad person or not? And this, of course, is a very discretionary decision. Ask your expert and immigration advisor. They'll be able to tell you if you have such a matter or you know somebody who does. They will be able to give you some hopefully fairly accurate idea about how Home Office caseworker is likely to make their decision.
Wow.
These things are all published somewhere, and your clever immigration advisor will know where to find them.
Fantastic. It's definitely worth having someone to advise you when dealing with this sort of complicated
Well, I mean,
situation.
this application is quite expensive, isn't it? You don't really want to waste your money on a hopeless application.
True. Let's say, and we do come across clients who have had some either caution or conviction, but it may have been 10, 15, 20, 25 years old now, and it was an incident in isolation. They haven't had any such issues again. How does that old incident or conviction, caution may impact their application now?
I think it would impact less. The longer ago it was, and if there haven't been any adverse matters since, the impact will be less and less depending on the time period. If it was, 10, 20 years ago, probably it's not going to have impact. If it's 30, 40 years ago, almost certainly. It's a sort of a sliding scale, pretty much. But as I said, it's a very discretionary type of decision making by the Home Office. It's changed. It was less discretionary. For one reason or another, in the last couple of years, the Home Office have changed the decision making to make it much more, have a much more discretionary flavour.
Okay, great. Well, I thank you for today's vlog.
I
and
thank you for
see
having me.
Brilliant. And see you in the next one.
See you next time.